Charlie, I gotta do something in my chair.
What are you, about 3 feet tall?
Where's the leader?
Really?
Okay. Thank you. What's your last name?
Camilla,
Camilla?
LLA,
C-O-M.
LLA.
How long you been a lawyer? 9 years. We just have 3. Where's my letter? You want to wait? You want to get started? You in a hurry? You are in a hurry. Okay. Thank you, Matt. Mm-hmm. At this time, we will call the Walton County Zoning Board of Adjustment meeting to order to September the 24th. If we would stand as we have our invocation followed by the pledge. Charlie, if you do the invocation.
Dear Lord, thank you for the opportunity to come here tonight and settle our differences. Thank you for the opportunity to live in this great county and this great nation. We ask that you watch over us here tonight and help us make the best decisions for our county and our citizens. Amen.
Amen.
Pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. I'd like to thank all the board members for being here tonight. We do have a full board, so we don't have an excuse to postpone. I'd like to thank Karen for her hard work in making this possible. Mr. Hayward Dice has resigned from the board, and we have a new attorney.
No.
Well,
Don't tell him that.
I tried, okay?
I'll tell him you tried.
Maybe we can vote. Miss Jennifer Camellia is going to be the representative on the legals tonight, and we thank you for being here, and hope you enjoy working with it. We appreciate Mr. Carpenter and planning staff and Ms. Frymire, and on behalf of the county attorney, we thank Sydney Noyes for being here. Are there any announcements need to be made at this time?
Yes, sir. We've received an email from the applicant on item number 1 requesting to withdraw their application.
Number 1?
Agenda item number 1, the North Beach Drive LLC variance.
Withdraw it or to with,
They're going to withdraw it. He's withdrawing it. So we don't need to take any action on that? Nope. Item number 2 will be continued to the October meeting, is that correct?
Yes, sir. That would be October 24th at 5 p.m. in this location.
Motion on that? I keep forgetting on it. We need a motion to continue item number 2.
make a motion to continue item number 2, the Gleeson Waldschidt Variance to the October 24th zoning board of adjustments meeting at this location, 5 p.m.
Second? Second. All in favor, aye?
Aye.
Opposed? So we down to 1? Sure. Item number 3, well, before we get started, let me take and do the swearing in. Anyone here that anticipates speaking before this board tonight, if you would stand, raise your right hand and swear that the testimony you give will be the truth to the best of your knowledge.
Do you swear or affirm that the testimony will give will be the truth, the whole truth, and nothing but the truth?
Hayden Appeal. State your name for the record.
Good evening, Mr. Chairman. My name is David Pleat, and members of the board, counsel. I represent James Hayden. He and his wife live at 98 Drive. If I could, before going into the substance of the appeal, I want to address an item. If you bear with me 1 second here. I want to address an item of procedure, and I'll direct it to your counsel. Yesterday afternoon, I received this binder. It is titled Intervener's Memo Responding to Appeal. The reason I'm bringing it to the attention of the board is that my client objects to an intervention in the appeal that is between my client and the county. The rules of procedure for these proceedings in Section 10 of the Land Development Code are very particular. They go to great lengths to explain the procedure for the appellate process in quasi-judicial proceedings. Nowhere found within those procedures, which are the law of the county, is there any portion of that which references the right of a non-appellant to intervene in the appeal before this body. I'll give you an analogy. In circuit court, there is such a process. There are rules of procedure, there are statutes, there's common law, which all goes to helping the trier of fact determine whether or not an intervener should be allowed to come into a case. Clearly, if the commissioners at the time had wanted to allow for intervention, they could have included it in the version of the Land Development Code appellate procedure for this process. They did not. Importantly, if you're going to allow the intervention of a non-party to this case to come into the case, I respectfully request that the board and the counsel to the board, I'll direct this to counsel, establish what the standing is. Why is it that they have standing to enter into this case, into my client's appeal? What is the basis in law for allowing an intervener to participate in my client's appeal? Essentially, having read through the material that was provided to me yesterday, it is arguing that the county needs assistance in arguing its case. The county is represented by a very able and experienced counsel who I've had many cases with. She's more than competent to argue the case for staff. To have an intervener come in is basically piling on, saying, we're going to also buttress whatever arguments the county has in defending the staff's action in this case. There are, I'd also point out that the interveners are not the property owners that own the property at the time of the approval of the lot split. These are subsequent purchasers who purchased July 31, about a week after the approval of the lot split. So we're not even dealing with the same owners, we're dealing with new corporate entities that have the same principal who own the lots currently. It opens up a Pandora's box. Again, you're going to have to decide during the proceedings, what are we going to allow the intervenor to do? Are we going to allow Mr. Pleat and the county to cross-examine potentially witnesses of the intervener? Are we going to allow final argument from the intervener? Are we going to allow the opportunity for them to question witnesses? Are we going to allow for rebuttal for the appellant after the county is gone and then after the intervener is gone? I do note in the memorandum that was submitted, there is no citation within the Land Development Code or Florida Rule of Civil Procedure for allowing this to happen. One final comment, if you allow this, then you've opened the door in the future for anybody who sees an appeal that they are interested in putting in their 2 cents to come forward and ask to intervene, and you will have set a precedent that non-appellant, non-county party has the right to come before this board in someone else's appeal and to intervene, or at least ask to intervene and participate in the process. And respectfully, I'd ask as a point of order, if the board through its counsel could explain if, number one, they're going to allow the intervention, and then what rules they're going to apply to the intervention, why they have standing, and what's the legal basis for allowing it.
Before we do that, unfortunately, I've misplaced my Land Development Code book. You said that there is a procedure in the Land Development Code, is that correct?
That's correct, Mr. Chairman. It's found at Administrative Decisions, Appeal to Board of Adjustment 10.012, and then 10.0203, Procedure for Quasi-Judicial Proceedings, which talks about burdens of proof, the order of presentation, the rules of evidence, the rights to question witnesses, et cetera.
Okay. Mr. Shipman, let Mr. Shipman state, what did you just state?
He decided it's been repealed.
Are you aware it's been,
The fundamental outline of how this procedure goes forward is still the same. And again, right, the reason I'm asking for a preliminary ruling is Mr. Shipman, who I have great respect for and have had many cases with, is already participating in this process. And I think before we even get to that process of having him participate, there has to be a fundamental decision made whether the intervenor is going to be allowed to participate.
well, now, in the past, we have allowed it. In the past, we have allowed the intervener to take the position of the county attorney, because it's my understanding in the past that the county attorney position was the same as the intervener. And answer to your question, yes, we do allow them to take full charge with witnessing and rebuttal and closing argument. And what I'm trying to make sure that the board, and that we understand, is there a procedure in the Land Development Code to outline that he can't. If he says it's been repealed, then we need to get that settled before we get a legal opinion from our counsel, in my opinion. Sure.
Okay, Matt. So as you pointed out, Mr. Johnson, this is a procedure that we follow oftentimes in this board. I believe Mr. Pleat is correct that there's not a specific procedure for an intervener to intervene in these decisions, but it is certainly not precluded by the Land Development Code. And in the past, we have always treated the property owner who would be impacted by the decisions of this board as we've treated them as having standing and allowed them to come and present arguments to this board. And those times when the county's position and the property owner's position are identical, which is the case here tonight, for brevity's sake, we have always allowed the attorney that represents the property owner to provide arguments for both the county and the property owner. And that is the case here. So I do want to make it clear on the record that the memorandum filed, I believe it was by Ms. Rogers from Mr. Shipman's office, and that was filed yesterday, September 24th, 2019. The arguments that are contained in that memorandum, the county adopts those arguments as its own. And so in this particular case where our arguments, the argument of the county and the property owner are identical, we would ask the board to allow Mr. Shipman to represent both the county and the property owner. And that's a procedure we followed in the past.
But let's clarify that Mr. Pleat said that the intervener does not represent anyone with standing. Now,
Yes, sir. So, I mean, I would respectfully disagree with Mr. Pleat that there's a lot of case law that a property owner has standing to argue before a board like this that would substantially impact that property owner's rights in a piece of real estate. And that would be the case here.
Mr. Shipman, how do you feel about your standing?
And as I cited in my memo, and as I've argued in front of this board before, in fact, with Mr. Pleat on the other side, the United States and the Florida Constitution specifically provide that you cannot take a property right away from us without us having due process, which means we are an essential party to this proceeding. If you held this proceeding without allowing the property owner to participate and present their argument, your ruling would be a nullity because it would be unconstitutional. The Constitution guarantees, both state and federal, that as a property owner, if the government is going to take action that would take our property rights away from us, which is what this is, we have to participate in the process. And this board has previously ruled exactly that way in other matters in which Mr. Pleat and I were on the opposite side before this board.
And I understand that. We're just trying to clear the air here a little bit, make sure that, you know, we all have an understanding. And Mr. Pleat says, did you not say that he did not represent the property owner?
No, he represents the applicant for the lot split. And I'm simply trying to understand the rules of engagement here. While I respect the argument of counsel, they have a remedy in circuit court. If they were unsuccessful in the outcome of this proceeding today, they could sue Walton County for all the reasons he just argued, due process rights, both state and federal. What I just heard from the county attorney, unless I misunderstood you, Ms. Noyes, which she was basically ceding the county's role in this case as counsel to the applicant attorney to conduct the proceeding. I may have overreached on that, but I thought that's what she just said.
I think that's pretty clear.
All right, so essentially the applicant is able to argue for the staff that I'm trying to present my case against and represent the county. And I find that to be inherently conflicted to have a citizen who has an interest along the way by applying for the lot splits to later be counsel to the county. It suggests a proximity, a closeness that I think unnecessarily taints the process.
But would you agree that the property owner has the right and standing for legal counsel to be here tonight?
He has a right to be here. The bigger question is the level of participation.
So is your own record stating that you don't think he has a right to intervene on behalf of the county?
At best, he would have a right to argue to intervene on behalf of the applicant, owner of the property, previous owner of the property. But to step in and say, I get to assume all the legal rights and standing of the county because I happen to own property that's involved in this case is a very large leap. And so at best, the relief that I thought was being requested was, I want to, meaning Mr. Shipman on behalf of his client, I want to participate. The county's going to participate and do its job. I want to be able to stand up and argue because I feel my client has a right to have that argument presented.
Johnson, now I have petitioned on behalf of the property owners to intervene. The Constitution of both the U.S. and the state of Florida guarantee that right. It's not that we're going to go through this process here and then I can go to the circuit court and challenge the constitutionality of it. You cannot take a property right away from a property owner without them being a participant in the process. You are appearing here as a quasi-judicial body. You're making a legal ruling tonight. We not only do we have a right to intervene, under the Constitution, you can't even conduct this proceeding without us being part of it because it is our property right, not the county's, not Mr. Pleat's client. It's our property right. They're asking you to revoke a property right that my clients have. If you do that without allowing us to be a participant, your ruling is in essence a nullity because it violates due process rights guaranteed under the federal and state constitution. I feel like Groundhog Day because I've made this same argument with Mr. Pleat before in this proceeding.
Mr. Shipman, I would appreciate, you understand that we have a whole new board. And I'm trying to make sure the whole board understands what we've done in the past and that you do, on behalf of this board and our council, have the right and standing to intervene. And I just want to get the discussion out there. Now I'm going to hear from our legal counsel.
Well, I think there's no doubt that the current property owners have a right to be heard today. The question is whether or not they can actually take the place of the county. So there isn't anything in the Walton County Land Development Code that provides for intervening. And since this isn't a courthouse, it's kind of a unique situation. I know in the past, generally, they would be allowed to speak and not be allowed to cross-examine either side. Obviously, that might be a difference if the county had a different position from the intervener. If Ms. Noyes is saying that they have the same position, then I guess it's up to the board how they want to handle that in that case.
But it's also in the past, it's been to, for like you have an intervener, the legal counsel, even though the intervener is going to lay out his argument tonight, if there's an appeal, there would be the intervener and yourself working on the appeal.
Right, and as a general statement, Mr. Shipman should be allowed to express his client's opinion here today, but the question is whether or not he can do it as the county or on behalf of the county versus just being the third party that can argue after Ms. Noyes and Mr.
I
Pleat.
feel like this has been before us many times, as Mr. Shipman has said, and I feel like that if there's a problem with the legality of it, that it would have been in the appeal process of the circuit court, the judge would have ruled that that was not allowed. That hasn't been allowed. There's been several that has been appealed. We've just had one appealed and it was taken care of and settled. So I feel like that the intervener has a right to step in as counsel for the county.
Right, point of order again, if I could, Mr. Johnson. Will the county also have opportunity to cross and speak the county attorney, or are they ceding the entire process to the?
It's my understanding that she is going to allow Mr. Shipman to do the full argument on behalf of the county and not step in. That's my understanding.
Right, and I do want to be clear, I'm not ceding any authority I have as the county attorney to Mr. Shipman, and I don't appreciate the insinuation that there might be some sort of close relationship that's allowing this. This is a normal process that we've taken. Mr. Shipman's going to be arguing to uphold the decision of the planning department. That is the same thing I would be doing.
But I don't think Mr. Pleat meant it as it was taken.
Okay.
Of course not. I think that Mr. Pleat's position and my position, we don't want to hear two arguments tonight. If you're going to allow him to intervene, then we really don't want to hear from you because you're giving that right up. Is that correct?
Yes, that's my point exactly.
Understood. I would still note my objection for the record, and I would also note for the record that it's my understanding, and Ms. Noyes can correct me, that the argument of the private citizen applicant, if this were to be appealed by my client, is the argument presented by the county for purposes of being able to tie in those arguments, those actions of the council during the proceedings to the county. That's where, like I said, this gets really murky. But as long as I have that representation that the county's argument is presented by the Private Citizens Council and they will be bound by that, then I still have my objection, but I think I understand with some clarity now how they wish to proceed.
I believe that's our understanding. That's my understanding, and that's why we're going to conduct the meeting. So
Yes, sir.
you're giving up your right,
Yes, sir. And to
allowing
be
the intervener, Mr. Shipman, to conduct this appeal on behalf of the county and his client.
Yes, sir. And to be clear, tonight I represent the county planning staff. So that's the position that's aligned with Mr. Shipman's.
And I think to be clear, I represent the property owners. My argument is essentially what the county wants to do.
Oh, I agree.
But I'm the property owner's lawyer, not the county.
And we're going to proceed with it. Mr. Pleat, you want to go ahead and address your appeal?
Very good, thank you very much. I've got some housekeeping, I have some items I want to put into the record of this case. The first is, and counsel should both have this, I'll be glad to show them an extra copy, is a copy of the Hayden Appeal that was filed before this body. If I could, I'll just pile up these exhibits over here if I could.
Where's your court reporter? Oh, we do have a court reporter.
She's hiding.
If we need to slow down, clarify, we'd be glad to do so. We just used to being up here, so.
The second two items, which I'll note as Exhibits 2A and 2B, are copies of the warranty deeds from the applicant to the corporations that purchased these two properties on July 31, 2019, along with copies of the Department of State printout for the corporations that purchased the properties. And I have extra copies of these for counsel if they need a copy, and would ask that this be made part of the record.
Do we have these in our binder?
These are items you do not have in your binders, Your Honor.
You're going to enter those in as evidence?
Yes.
You're going How many are you entering?
I have these two, and I have extra copies of these for,
We need it to be entered into the
yes, the first item, which was a copy of the Hayden Appeal, is Exhibit 1 for the appellant. And Exhibits 2A is the Bagwell to All About Beach Investments deed.
and you have those copies?
I do. And 2B is the deed from the Decors of 24 Sea Turtle to 501 Dream Big Investments.
So that's three? Exhibit A, B, and C, is that how we doing this?
I did that as 1
One, two.
and 2A and 2B.
So entered into the record.
Thank you. The next item is a single page. I'll give a copy to,
Let us get this here passed around, so.
okay? I have extra copies. It's also on the slideshow, but I'll be glad to provide copies if you wish.
I like to have one copy to take with me to make, when we start doing the final order, I need a copy. Do y'all want a copy of this to look at?
Yes, please.
We like to have a full copy. I mean, surely they can provide us copies.
Exhibit 3, marked for identification purposes that I would like to make part of this record, is a timeline. It's titled Timeline, single page.
I have a,
Oh,
Just put this back in there.
all right.
The next item, which I will mark as Exhibit 4, single page, and I do have extra copies.
Mr. Pleat, you need to just help us here now.
Hold
What-
on a second
What is
there.
this? Is this one,
That is one. That is a copy of the appeal, which,
which is number one?
yes.
And which one's number two?
2A is coming.
2A is the Bagwell deed, 2B is the Decor deed.
Are they attached?
no, there's two separate ones coming, so just, that's 2A.
2A. All right, would,
3.
And Mr. Johnson, I'll wait till I get a sign from you before trying to put another one in.
just hang on. We're ready, Mr. Lee.
Thank you. Item 4 is a single page. It's a photograph depicting the location of the current fire hydrant across the street from Sea Turtle.
Mr. Pass. We're ready.
And Exhibit 5, which is the final item I'm moving to introduce into this record, that's not part of the appeal exhibits, is a photograph of a picture from Tim O'Hare, who's a builder who will be building homes on these lots, given to my client as a depiction of the type of home that will be constructed on these lots. This is Exhibit 5.
Just to clarify, exactly what are you doing? I mean, who you represent? I mean,
As I indicated, I represent James Hayden. I was going to explain that as I started the
oh, okay.
presentation.
All right, I just, sorry about that. I just want to make sure we understand.
If, Ms. Karen, could I ask
Excuse
you a
me,
question?
Mr. Chairman, and at some point, I have a right to object to some of these exhibits. I've been quiet while he's been doing it. But the Land Development Code
Right
in
there, okay.
particular, Section 113.09, subsection
Thank you.
B3, specifically provides that the Board of Adjustments shall consider the appeal at a public hearing. The scope of the board's review shall be limited to determining whether the administrative decision by the director was correct and in accordance with the intent and requirement of the code. Now, he hasn't tried to explain what relevance any of these documents are, but I will suggest that at some point, based on what he's presenting here, most of this has nothing to do with what the Land Development Code requires you to consider, which is the sole issue of whether or not the planning department, in their determination that we were allowed a lot split, was correct with its, was correct and in accordance with the intent and
But
requirement of the
Mr. Chair,
code.
point of order.
Let him finish.
But
So
this
at
is
some
the
point-
appellant's case.
At some point,
Hang on a minute.
he's going to have to, I'm not conceding that any of this stuff is admissible. At some point, he's going to have to bring this in and tie it in to how it fits that requirement of the development code. For example, with timeline, a picture of what a
Objection,
house would look
objection.
like.
This is the appellee arguing their case. I haven't even begun the appellant's
If
case.
you just hang on a minute, we'll get this worked out. Mr. Shipman, go ahead.
So I don't want to be interpreted that I'm waiving any right to object to these exhibits, because I think most of them are irrelevant. I want him to have to try to move them into evidence, and he's going to have to tie how it's related to what the standard is in the planning code. So he's right now just handing them in. I'm quietly letting him hand them in, but that does not mean that they come into evidence. I get to object as to whether or not they
You get
actually
to
meet the
object,
code.
and I tell you what we would do. He's going to start with item number 1. He brings it in to your clarification. You good with it? If not, you object, and we'll make a decision. Fair
Yes, sir.
enough?
Yes, sir.
But you understand we're going to give him some leeway to paint us a picture exactly why he's here, and you have the right to,
Fully agree.
okay, bear with us and we'll get there. Go ahead, Ms. Pleat.
Thank you. This is the presentation of the Hayden Appeal of the ruling of staff to permit the lot splits on 2 lots located off of Sea Turtle Drive. I have before you, as you can see on the PowerPoint program, for illustration purposes and to provide some context for your review of this matter, a copy of a picture taken from 30A looking to the south, and that is Sea Turtle Drive. As you can see, and as the evidence will show, it's 14-foot wide, very narrow street. There's a total of 8 lots on this street in this community. 2 of the lots in front are the lots that are at issue with the lot split application. That's another picture as well of the street looking to the south. One more for illustration purposes. Again, you can see a car parked on the side, looks like a service vehicle, and the very narrow width of this particular roadway. The next slide, which is page 6 of the packet that you have, is a bird's eye view of Sea Turtle. The parcel that has a single home on it surrounded in a red boundary is the DeCur property. That was the applicant at the time. They no longer own the property. And the one immediately to their east on the other side of Sea Turtle, abutting 30A, is the Bagwell property, which also has been sold since the approval of the lot split. The next item on page 7, and please stop me at any time if you have any questions or I'm going too fast. On page 7 is from Volker Surveying, which is the surveyor for the applicants, reflecting the location on the east and west side of the current structures of the applicant lots, both on the east and west side, single-family structures. Again, from the Volker Surveying Group, on behalf of the applicants for the lot splits, page 8 reflects what these parcels will look like upon the lot splits and the intent to build 4 homes where there were 2. I want to begin with this story with the beginning of the story of the application. In this particular matter, the application was presented on behalf of the Bagwells and the DeCurs by Heather Williams, who was their agent pursuant to the filing with the staff. In this pre-application notes, you'll see that they reference neighborhood infill, that it has to meet compatibility analysis and all requirements. So from the very beginning, looking at neighborhood infill 2.0214, there was an indication from staff that this application will have to meet compatibility standards in all requirements and analysis. And this is at the end of March 2019, several months ago, when this process began. On page 10 is simply illustrative. It's part of the file, and I will note that all of these documents and emails were provided to my office pursuant to a statutory public records request in the response from the county. Aaron Cracker, who's the environmental planner, sent to Mr. Lambert, the project manager for the lot split application, notes regarding environmental review, which is consistent with the neighborhood infill compatibility review, and certain notations of requirements, including the preservation requirements of section 4.05, applying to all parcels off of 30A. But item 11 is Mr. Matt Lambert getting an email from Mr. Sanchez, who's the fire marshal for the South Walton Fire District. And if I could read this into the record, good morning, hope all is well. We have 2 lot split applications located on Sea Turtle Drive. It is a private drive for ingress and egress. The private drive is 14 feet at max width. There are currently 6 houses already on the drive. This would add 2 more dwelling units on the private short drive. Mac and I, referring to Mr. Carpenter, the planning director, are of the mindset to deny based on the increased traffic on this narrow road. Side note, we do have 3 of the property owners have filed objections. So as of May 23rd, there was the inclination to deny in this particular email based upon the increased traffic concern, which was part of the review, and this was proceeding under a compatibility review. On the next page, which is 12, this is again a document from the staff. It's the technical review title to it, staff findings of fact. This is signed on May 28th, so it's approximately 2 months after the application. On 5/28, it's signed by Mac Carpenter, Planning Director. The request for lot split is being denied due to the increase of traffic resulting from the lot split along the 14-foot wide private drive, Sea Turtle Drive, and due to fire safety from the private drive being more than 150 feet without an adequate turnaround. And that was the basis for the denial 2 months into the process.
May I stop you there for a minute?
Yes, sir.
Let's see. Up where it says density, allowed 8 dwellings per acre, proposed, create 2 lots in half.
I think that's the requirement for neighborhood infill. That's my understanding.
Need it?
Excuse me?
Does this lot split, do they still meet that density?
Well, in a vacuum, as to number of units, yes, but that's just one criteria that staff has to review in determining whether or not to approve, in this case, the lot split, or what I will explain in a moment, was a minor development order requirement. So that's on the 28th, and at item 13 of the PowerPoint, May 28th, 2019, the same date as the denial. You have an email from to the Walton County Planning Department from Mr. Sanchez, the fire marshal. And it reads in pertinent part, the proposed project does not appear to meet our technical review approval at this time. The existing dead-end access roadway appears to exceed 100 feet threshold. Dead-end roadways that exceed 150 feet shall be equipped with an approved turnaround for fire apparatus. In addition, the existing access roadway is only 14 feet in width. The addition of more structures would necessitate the need to review the roadway to meet the 20-foot minimum. As approved, fire hydrant shall be listed and shall be located no further than 500 feet. I will note from the exhibit that I've put into the board, the picture of the existing fire hydrant, which is directly across the street from Sea Turtle Drive. That's already there. On page 14,
Now, just hang on a minute. What are you talking, are you trying to bring the fire hydrant in? So tell me about that again.
yes, if I could pull it out.
You're going to Exhibit 4?
Yes, and as you can see from this exhibit, this is the currently existing fire hydrant across from Sea Turtle entrance, which already exists. And directly to the south of the yellow boundary box that's added to this picture, you'll see the 2 lots which are the subject of this particular proceeding.
Are you saying it's within the 500 feet?
It's my understanding, yes.
Okay.
Going back to Exhibit 13.
His basis, he is limited basis of what he filed on an appeal. There is nothing in this appeal that he filed about fire hydrants or lengths of fire hydrants. If you look at what he said in his appeal, he alleged 2 things. He alleged that the fire department didn't approve it, and he alleged that it impacted traffic and we didn't address traffic. That's all he alleged in his appeal. He's limited to his appeal because, again, this is a due process proceeding. So we have to have notice of what he was going to argue, to appeal, so that we could respond. He doesn't get to go outside what he filed on appeal. So we object to this fire hydrant. It gets back to what I was talking, we haven't gotten all the documents.
You're objecting to Exhibit 4, correct?
Yes, sir.
Overruled. Other one? Go ahead, Mr. Pleat.
Thank you, Your Honor. Page 14 of the PowerPoint presentation, email from Matthew Lambert. Again, this is a document produced by the county pursuant to the public records request. Wednesday, June 26, 2019. So we're now several months away from the original application. Here's another letter sent to myself and Sydney for your records. After our discussion, we have requested that they, referring to the applicants, do a minor development order and be reviewed as such, since things need to be shown on the plat, hydrant, wider easement, and thus. So as of June 26, the staff had come to the conclusion, again, that a minor development order was required for the construction of these 4 large homes on Sea Turtle Drive. Page 15, another email. This is going to my office from Mr. Lambert. This is dated June 27th, indicating he had just met with our legal department, meaning the county's legal department, and the director of planning. We have decided that the lot split, as is applied for, will stand as being denied. So several months into this, once again, a month after the initial denial, there's another indication that it stands. It's denied. They were given the option to apply for a minor DO, again, reference to the requirement to have a minor development order that would have to go before the TRC for a public hearing. They will let me know what they decide to do, and if they do go that route, all property owners within 300 feet will be notified. Next, turning to page 16 is an email that was produced, and this is coming from to Matthew Lambert from a representative of Dunlap and Shipman, who represent the applicants. And what's germane about this to this appeal is the second line in the last paragraph. It is our understanding that you told her the planning department recommends that they set a pre-application meeting for a minor development order instead of lot splits. The client's right to appeal is time sensitive and must be preserved. Therefore, at this time, we will not withdraw the appeal. The property is under contract to close at the end of July, and the Zoning Board of Adjustment scheduled for July 25th is critical. So for the first time in the public record that I received, after continual denials of the application, continued references to the need to have a minor development order, for the first time, the private citizens' indication that they are scheduled for a closing and it's imminent comes into the critical analysis in this file and is presented to the county, to Mr. Lambert, as something obviously they wanted him to consider, that there's a pending sale in this case just weeks away.
Excuse me, Mr. Chairman. Again, I want to object to this and the timeline. Not only is this outside the scope of what they filed an appeal on, it does not meet, this is not evidence of the sole issue that this board gets to look at under the planning code, which is whether or not the planning department in approving the lot split met the requirements under the code. What's required here tonight is they have to show evidence of, here's a provision under the code that the planning department overlooked, or this is not complying with. It's not about trying to prove some sort of conspiracy theory, which I think we're trying to hear now. It is about, did we meet the requirements of the code or not? Period.
And I'll be glad to make my argument at the end of my presentation.
Second, he has an objection, and Mr. Shipman, you know that we allow a little bit of leeway here because it's explaining, and I understand your point, but explaining and what he is doing is what I asked him to do, is to explain why we're here.
Yes, sir.
Now, he is, in my opinion, doing a good job going through this application process so that we understand the process. And I think if we give him the opportunity to complete his presentation, then I'm hoping that you can tell us why what happened did happen, but we will have a clear picture of it.
Yes, sir. I just don't want to waive any right I have to object, and as he gets into these things,
Then we're going to overrule your objection one more time.
thank you.
Thank you, Mr. Chair. And finally, in this June 27th email, it's indicated that they were requesting the applicant through their counsel a meeting early next week with Mac Carpenter and Sydney Noyes to discuss the suggestion of a minor development order. This is June 27th. The next exhibit is Exhibit 17 in the timeline. It's from Ms. Yule to Ms. Noyes. Paragraph 2 is germane to the arguments I will be presenting at the end of this case. Fire Marshal Sanchez forwarded to me an email from Mr. Lambert that the county had decided to require the landowner to submit a minor development order for the project. Thus, the letters from the homeowner and attorneys are not necessarily moot, but the response will be different. I also understand that they will be submitting a request for a lot split of 2 rather than the previous requested 4 houses. I bring that to the attention because once again, there's the reference to the fact that staff on July 8th now, just weeks before the scheduled appeal and the scheduled closing on these properties, that there was still the requirement for a minor development order from staff. On July 19th, which is Friday before the scheduled appeal by the applicant of the denial, 3 months after this process began, Ms. Noyes to Mr. Carpenter, we need to speak Monday, which would be the Monday before the Thursday appeal was to be heard before this board, so we can finalize our decision on Sea Turtle and whether it should be a minor DO or a lot split. I told Gary Shipman we would let them know on Monday so they could plan accordingly for the Board of Adjustments hearing on Thursday. That's Monday, the week of the Thursday appeal hearing scheduled on the agenda before this body. I'm going to skip to page 21. July 25th. Now 4 months approximately after April, May, June, July, 4 months from the application. And only on the same day the scheduled appeal to be heard before this body. On July 25th, there's a complete reversal. On July 25th, there's no talk of requirement of a minor development order. There's no talk of the safety concerns raised by Fire Marshal Sanchez. There's simply an about face on the day of, the afternoon of, the hearing on the applicant's appeal. The stated reason under the technical review portion, staff finding of facts, the request for lot split is being approved with the condition below. Fire hydrant will be installed with 100 feet of the entrance of the subdivision, which condition will be met prior to the issuance of certificate of occupancy for any residents on the 2 newly created parcels.
Mr. Pleat,
Yes, sir.
sometimes I'm a little slow. Am I right to believe they were asking for a 4-lot split, and now it's gone down to 2-lot split?
I saw nothing in the file that reflected that they wanted to put 4 on a lot. It was always they wanted to split the lots where there's 1 house on each parcel and make it 2 parcels with 2 houses, so a total of 4 houses.
But they're only splitting at one time.
That is correct. So for the first time, again, on the...
Just hang on. a
Okay.
minute. You skipped one of these that's, let's see, which one did you skip? You skipped the one,
There was a reference to setbacks on page 20.
and you don't think that had any bearing on their decision?
I don't know. It's not referenced in the findings, staff findings of fact.
Let's go back to 17.
Okay.
Mr. Chick, address that.
On page 17.
Yes.
I also understand that they will be submitting a request for a lot split of 2 rather than the previous request for 4 houses per previous lot.
And I have no explanation for that. I see nothing in the application or the materials I received from the county to suggest that they started this process seeking to put 2 houses per lot, or a total of 4 houses on the existing, each existing lot.
Is an approval of a 2 lots being split into 4. and
Correct.
this email referencing 2 lots being split into 4 houses.
Which would be.
Yeah, total of 4.
Four
Total of 4 houses.
says per previous lot.
And again, I have nothing in this file to suggest they wanted to put 4 houses on each lot upon lot split, that it was going to be a lot split with 2 houses where there was 1 on each lot.
The county that can clarify if this is the reason why it was approved?
I don't know, and the county can present that perhaps in their case. if I could,
But while we touched on that, you do agree that they could have put 8 houses instead of 4. You agree with the density will allow that?
that fits with the Land Development Code description of neighborhood infill. So, yes, in a vacuum, yes.
Okay.
Back to page 21, again, the only stated reason was that they changed their mind and said you're going to have to put a fire hydrant in. No talk of compatibility, no talk of,
Which one, you on 21?
page 21.
What about the note on page?
Yeah, that's a reference to discussions about setbacks between the applicant's attorney and Mr. Carpenter. And that's on July 25th, the date of the appeal. But my client's relying upon the staff findings of fact to try to get a peek into the mentality of staff as to why they did a 180-degree turnaround on the date of the appeal.
That's why I'm asking about the comment. Says, if you correct front setback for the above, survey sketch, approved lot.
I understand that that reflects a conversation, but it is not listed as one of the conditions for the approval on the penultimate document, which is the staff findings of fact and the decision of the staff. One would think, respectfully, that if there were other reasons for the about face on the decision, they would have been cataloged quite clearly in this particular document. And just on page 22, I just point this out as a technical matter. The file was not complete when they approved the lot splits on the 25th. There was a missing affidavit, which eventually was produced on the 26th. But as a technical matter, the approval occurred without a complete file. If I could go to page 26. This date is July 30th. I had been corresponding, as you can see from the record here, with Mr. Lambert from time to time on behalf of my client, trying to keep up with the status of matters. And I had seen it on the agenda, but then there was no action taken, and I was uncertain as to why. The response on July 30th, which is the Tuesday after the Thursday when the deal was cut between the county and the applicants, he responded, they had filed an appeal with us. Prior to the meeting, our county attorney and Mac and SWFD discussed what needed to be done. They at this time have been given approval for the 2 lot split applications with the condition that a fire hydrant must be placed within 100 feet of the entrance to the subdivision prior to COs being issued. They also had to increase the deeded easement to 20 feet wide. They meet our requirements. So, through that date, up until about a week before, there was, I'm sorry, if I could go to 28 real quick as well. This is from Matthew Lambert again to myself on Wednesday, the 31st, indicating it was settled prior to the meeting, so it was not heard, meaning the applicant's appeal. Attached is the final approval of the lot splits with their conditions. And beginning at 29 is simply a copy of the formal filing of the appeal. And I will summarize as follows the appellant's case. The appellant, relying upon the staff's own documents and own communications, understood that the staff was requiring a compatibility analysis pursuant to the neighborhood infill sections of the Land Development Code 20214. They understood from the 3 months following the application, the constant reference to the need for a minor development order. And I will argue and suggest that's because they knew this was going to be essentially one project. One project, 4 large homes burdening the street, which you can see is quite tiny and not necessarily compatible with the rest of the neighborhood that they're infilling within. It wasn't until the interjection of the idea that the private landowner had a closing pending that in the last few days before the applicant's appeal before this body, that you see a change of position No more reference to the need for a minor development order. 3 months of it, but not in the days before the appeal and not until after the reference to the closing pending. You will see from the documents submitting the closing did occur on July 31st, a week after the scheduled applicant's appeal. The concerns of Fire Marshal Sanchez weren't referenced with the exception of the need for a fire hydrant, weren't referenced in the statement of staff findings of fact when the about face occurred just prior to the appeal being heard. No reference to the apparatus turnaround, the safety concerns, the statements in writing from the fire marshal that he can't approve it because of that. No reference to how compatibility or traffic would be addressed. And as a result, my clients are left with the only explanation being a fire hydrant when one exists across the street. So I would suggest that the staff was on the right track for months. It was going through the process of making the applicant go through the minor development order process, which is much more involved, public hearings, technical review, et cetera. Instead, that got changed at the last minute. They also weren't going to approve on multiple occasions because of safety concerns, which are the concerns that the other residents in that community have as well. Those were abandoned in favor of a single condition, which was a fire hydrant within 100 feet.
Was not the increase of the width of the road also considered to be an avenue to address the safety issues?
It could be, Mr. Johnson, but in the staff findings of fact, the only condition laid down for the applicants in order for their approval to get a CO was a fire hydrant. There's no mention of setbacks. There's no mention of anything else at all except for the need for a fire hydrant. You put a fire hydrant up, you'll get your CO.
The setbacks was addressed, I think, in item 18, 19, was it not?
There was discussion regarding setbacks, yes, sir.
And they did meet the setbacks. So
I do not know. That normally would be a condition of approval, that you're going to have to ensure certain setbacks.
Is it not in your documentation? I mean, clearly, we addressed that a few minutes ago. It was 18 or 19, you skipped it, and it said that they did meet the setbacks. If you correct, the front setbacks per the above of the survey sketch would be approved. We can approve the lots split as agreed on Monday.
Right, there was some deal made on Monday
But
regarding setbacks.
you said it wasn't addressed, but it was addressed.
If you
It's
could
in
just,
item number 20.
it's a bit nuanced, if you would, Mr. Johnson, because yes, the record reflects they were meeting in the days before the application. Yes, there's discussion of setbacks. To the extent they reached agreement, there's no requirement within the staff findings of fact, a conditional requirement that you meet the following setbacks, which is quite typical from staff findings of fact when they have conditions for moving forward. So that is, while there's discussion, and I wasn't privy to any of these discussions in these last few days before the appeal, I don't know what was discussed and agreed to other than what I see in the public record. All I know is I know there was a complete change of position on behalf of my client, limited to a single criteria and a single standard. And if I could just add, if I were told later I've got more conditions to my approval, I would pull this out if I was the applicant. And I said, no, wait a second. You told me all I got to do is put a fire hydrant in, and I'm good to go. So tell me why I have any other conditions that are required of me.
That way.
Do you see other conditions on that finding of fact?
I saw where they widened the access road from 14 feet, which is one of the things that fire marshal said was inadequate. And so by widening the road from 14 to 20 feet, and then also when you do a lot split, the new houses would have to meet the stormwater requirements. And I saw where you had a picture of flooding in the street.
Yes.
New for the houses would have a place which would eliminate that stormwater problem in the street. And then he talked about the dead end street being 150 feet. So by locating the fire hydrant closer to the site, they could eliminate the requirement for the dead end turnaround.
Still no discussion of traffic concerns, compatibility concerns.
development order requirement, but they decided to approve it as a lot split, right?
But they continually said it was required to be a minor development order.
They said they were considering it as a development order, not a requirement. And I
They-
think we should hear from Mac Carpenter, who ultimately made the decision
We
to
will.
make it a lot
We,
split.
And respectfully, now the statement was they told the applicant they will have to proceed under a minor development order process.
we'll let him finish.
Well,
So going back, to,
Hang on a minute.
yes, sir.
the setback issue would be addressed in the actual surveys that are recorded with the lot splits. So you'd have that and meet that criteria through what was actually recorded.
Okay.
So to complete the summary, Mr. Chair, the failure to continue with what my client believes was the appropriate process, compatibility, minor development order, the sudden change, the single condition, it's my client's position on appeal that this was wrongfully approved in the last minute to be a lot split, contrary to the evidence in the case on what should have happened. And my client asks as a request of the board that they grant the appeal and reverse the decision of staff approving the lot split for the two applicants.
Before you sit down, let's go back to exactly what you asking us to do.
Okay?
The appeal, this is an appeal of the planning department, and you're asking us to overturn his decision on the lot split.
That is correct.
Both lots, there's two lots.
Correct, two lots, applications for lot split on both lots were approved, and the ultimate decision that's pending here before this body.
And the reason you asking for that is so they go do MO, minor
I'm
development.
sorry.
Minor development, is that correct?
Yes, because they didn't conduct it through the procedure they were mandating, which was a minor development order. They didn't fully analyze and complete compatibility with the rest of the community in approving the construction of these the lot splits and the building of 4 homes instead of 2. And as a result, the remaining 6 lot owners will be unduly burdened by the increased traffic, number of people, and the size of these homes on this very small street.
And your client lives in that subdivision?
He lives at the very end on the beach in lot 68, and he has a vacant lot next to him as well.
Does live in this subdivision?
Yes, sir.
Thank you.
Thank you.
Mr. Johnson, just as a point of procedure, I don't believe that Mr. Shipman said whether or not he objected to the rest of the exhibits that weren't actually discussed. So you might want to address that, whether or not they're entered into evidence or not. I don't know if there is any objection to those, but we actually only discussed number 4 and number 1, I believe.
Mr. Shipman, do you agree to allow 2A, 2B, 3, and 5 entered into evidence?
Those are the deeds, the picture of the fire hydrant, and the picture of the proposed type of,
Fire hydrant is item number 4.
yes.
That was already entered.
That's already in, okay.
I don't have an objection to the fire hydrant. I do have an objection to the quote, proposed type of houses. We're not here on a building permit. This is a lot
Number
split.
5.
Whatever,
I'll sustain that objection. We won't allow that. How about number 3?
what is that? I'm sorry, which is
The
number? 3?
timeline?
Timeline?
It's already gone through it, but I want to record an objection because I don't think it meets the requirements of what you're appealing. Been
We'll
said.
overrule that one. What about 2A?
Those are the deeds, Mr.
I don't
Shipman.
object to the deeds.
You object to the deed?
No, I do not.
2B is a deed?
That's correct.
I do not object to those.
Offender. Thank you, ma'am.
Thank you, Mr. Johnson.
Not. But we may. If you want to, we will.
I'm not sure if the members got the notebook that we submitted or not. I was going to provide a copy to counsel if she doesn't have it, so, okay. I wanted, even though it's in the notebook, I want to make a separate exhibit because it wasn't talked about at all in the previous presentation of the email from Sammy Sanchez, where after further review, he's the one who said he would approve it, provided that the existing roadway not be extended in length, the easements be widened to 20 feet along the parcels that are being split, and a fire hydrant installed within 100 feet of the entrance of the subdivision. So I'd like to make that a separate one, because that was not included in what we talked about earlier.
We need to enter this at the staff, is this treated as a staff report? We need to enter this into evidence as, how we gonna?
Are you
enter this?
asking for the entire binder to be entered into
Yes.
evidence?
Yes.
Yes,
The rule on that, of whether that can be entered.
gonna enter it.
Okay.
Yes. We overruled your objection. Now, this is it, this is the A. And
Would you like it to be A, since he used numbers? I believe that's already in there. It's number 3.
I don't think so.
Yeah, it is.
It's in the book?
Yeah, 3.
Yes, sir.
I'd like to admit into evidence, I guess this would be B, because it's not in the notebook.
It is in the notebook.
No, I have an exhibit that's not in the notebook. There had been previously another lot in this neighborhood, essentially the same size lot, that had previously been granted a lot split, the same thing we're doing here.
Okay, we got Exhibit A, that's Exhibit B.
Yes, sir.
Mr. Pleat, you have a copy of it? Go to rule, we allow it.
Okay, before I have Mr. Carpenter come up here, I wanted to discuss, and I wanted to point out in Exhibit A, there was this discussion about compatibility analysis, which is not required as part of a lot split.
Hang on a minute, Mr. Shipman, I'm a little confused. They gave me a bunch of papers here, exactly what are we supposed to be getting?
You would have this notebook, which would be A.
Oh, this is added.
That is a approval of a lot split on another lot on this same street of the same size, or roughly the same size, where exactly the same thing that was sought here is granted.
Exhibit D? Okay,
Now, even though for a lot split under the planning code, a compatibility analysis is not required, one was prepared and submitted on behalf of my client's predecessor owners, and that is tab 6 in Exhibit A. And I guess there were two different, were there two different compatibility? What's the other? Okay, they're both under tab 6. So we did a compatibility analysis for both parcels, and it was provided to the planning department. And the reason I wanted to bring this up is even though under the planning code for a lot split, there is no requirement for a traffic compatibility study. In fact, based on the Rinker case from 1973, the fact that the planning code specifically only requires this under a less than minor, minor, and major development order. So under the Rinker case, the county couldn't require compatibility analysis on a lot split. We did it anyway and provided it to them. And under that compatibility analysis on the traffic, which is one of the two issues that they complained about in their appeal, the compatibility analysis found that the traffic by doing these lot splits would be increased from 2 trips per peak PM hour, which is the test, to 3. The planning code defines de minimis impact as 5 or less per peak PM hour. So even though it's our position that there is no requirement, and there can't be a requirement under the Florida Supreme Court ruling in Rinker to require a compatibility analysis and traffic study on a lot split, we did it anyway. And when we did it, the impact was de minimis, increasing the amount of trips from 2 to 3, which makes it de minimis under the planning code, which even if we were going under a minor development order where it was required, the exception is when it's de minimis, which it is here. I'd also point out that you're looking at the actual road that the lots are on, which would be Sea Turtle Drive. These 2 lots are at the very top of the road. So to the extent there's any additional traffic, it's only in front of these 2 lots. It's not in the front of the rest of the neighborhood. So it wouldn't impact Mr. Hayden at all. Now, briefly going through the provisions of the planning code that I think are relevant for your decisions, and I sort of brought this up earlier. Under tab 7, section 1.13.09, section B3, the Board of Adjustments shall consider the appeal at public hearing. The scope of the board's review shall be limited to determining whether the administrative decision by the director was correct and in accordance with intent and requirements of this code. That's all you get to consider, whether or not it met the planning code. I want to point out the provisions regarding lot split, which is defined under section, it's the same numerical section, but it would be G, which is over on top of page 40. It specifically sets forth what's required for a minor lot split and what falls under a minor lot split. A minor lot split is where you have one single parcel of land that is being divided into 2 separate lots or parcels. Meaning this is a recorded lot of record, and they're splitting it into 2 recorded lots of record. This is not a unsubdivided tract of land. And the request and the what was provided or approved by the planning department was to split a lot into 2 lots.
On page 40 of 63, what paragraph?
G.
Okay, got you.
Okay. If you go down, and there's no question that it hadn't been, it had not been split or combined before. Then under the review process, it requires what must be submitted. You have to submit it on the form by the planning department. That's been provided to you. There's no question about that. We have to provide the required fee. There's no question about that. We have to submit 3 paper copies of the proposed minor replat or lot split, a statement indicating whether water or sanitary sewer service is available to the property. I don't think that's been debated. Regional Utilities provides that, and it's located there. Land description and a statement of acreage or square footage of the original and proposed lots, along with a scale drawing showing the intended division, all prepared by a professional land surveyor registered in the state of Florida. That was provided, I believe it was Vogler did that. And then it states, in the event a lot contains any principal or accessory structures, a survey showing the structures on the lot prepared by a professional land surveyor registered in the state of Florida. All that was done. Now, we heard a lot about, well, at one time they thought we were supposed to be doing a minor development order versus a lot split, and suddenly they changed. The Land Development Code goes on to provide that if, upon review, they determine that something, it's incomplete or there needs to be something corrected on it, they're supposed to give us notice and give us an opportunity to correct it, which is exactly what happened here. We did file an appeal, and then we said, hey, wait a minute, you told us we're supposed to have an opportunity to correct it, and we did. We widened the easement to 20 feet, like Mr. Sanchez agreed, which, by the way, since we're going through all this timeline, Mr. Sanchez's letter where he reconsidered was dated June 17th. So they got to consider all this well before. It wasn't a last-minute backdoor deal, as it was been suggested here. There is no requirement, as we already discussed, under the Development Code for a compatibility study or traffic study. It's not in here. And again, under the Rinker case, because land development codes or zoning regulations are a degradation of common law, meaning they are changing what at common law a property owner's rights were. You have to strictly construe them, and you have to construe them in favor of the property owner. So you can't impose a requirement that isn't there. Now, the Florida Supreme Court decided that way back in 1973. I know I've stood up here before and talked about Rinker. There is no requirement for this. But because they talked about a minor development order, we did it anyway. And there is no impact on the traffic. Now, in their appeal, which they're limited to what they raised in their appeal, they raised two issues. It was what the fire department said, and they skipped over and didn't bring up in their appeal what Mr. Sanchez's ultimate position was, which was you had to widen the easement and add a fire hydrant, which we agreed to do, and is in the approval portion by Mr. Carpenter, and about traffic, and it was de minimis, and we did do a compatibility study. There is nothing else. There was nothing else in their appeal raised. So you're limited to what they raised in their appeal, and you're limited to whether we met the requirements under this planning code. Yes.
I think it's more interesting to continue reading about what a minor development plan, what triggers a minor development plan, which is division of land into more than two parcels.
Yes, sir.
A lot being split into two lots, where's the requirement for it being a minor development?
And I raised that with the planning department, and they ultimately agreed. And in fact, also, if you read that, where it talks about being split into more than two, it also talks about a single parcel of land is being divided as opposed to a lot. So this is clearly a minor development order, is where you're talking about originally platting a piece of land, as opposed to taking an already platted lot and simply splitting it in half. minor development order wouldn't apply to what we're doing here. Unless we had already either split the lot, or somebody had, or had combined two lots previously. Unless you met those conditions, the minor development order does not apply. And again, under the Rinker case, and the reason why I emphasize the word parcel of land, to the extent there's ambiguity as to what that means, it has to be construed in favor of the property owner.
I have a question.
Yes, sir.
The density allows 8 units on this, is that correct?
Yes, sir. And,
You could do a minor development, but 8 units.
well, we don't have, each parcel is not an acre in size, but yes, if we had a whole acre, yes.
So you could put more than what you are asking to put there.
Yes, sir. I believe under the density, and I'd have to again look at the precise acreage, but I think under a minor development order, we could have done 3 lots per lot.
So you could put 6.
Yes, sir. Yes, sir. At this point, what I'd like to do, so I think everybody needs to hear from Mr. Carpenter. I'd like to bring Mr. Carpenter up here and have him provide some testimony.
Yes, sir.
Mac Carpenter for the Planning Department, Carpenter.
Mr. Carpenter, you heard discussion about why.
Two reasons primarily. One, it appeared that we were taking essentially an assembly of parcels owned by the same person and creating 4 lots. That was not the case. 2 separate lots, they happened to be adjacent, owned by 2 separate people making 2 separate applications. Each lot was a lot of record. They're entitled to a one-time lot split on a lot of record, providing it meets the density of a land use category that it's within. The compatibility analysis absolutely proved the density, but we would have done that analysis separately to ensure that it meets the requirements of the Land Development Code, because that is one of the requirements in the lot split process. The lots being created have to meet the other requirements of the Land Development Code. The lot split process is exempted from the development order process by code. The other factor that we never overrule is fire life safety as determined by the fire marshal for the area that the development is in. In this first case, he indicated that it did not meet the requirements because it didn't have 150-foot or exceeded the 150-foot length of roadway without a turnaround. We went back and took another look at that, determined that there is a fire hydrant within the required distance. There is also the 150 feet is not the extent of this project. The 2 lots to be split are right up adjacent to the roadway, not in the very back down the roadway. Initially, it came to me that this was a 14-foot wide easement. That's typically not an adequate access for the fire department. They're looking for 20 feet. We did discuss that. Sammy was happy with 20 feet and the fire hydrant within the proximity that he specified, and that changed our decision completely. Yes, it was. That a fire hydrant be located within 100 feet of the entrance of this development. It absolutely does. Each of them absolutely does.
Address the, just a minute, address the setback.
Additionally, they'll set back from the extent of the easement. When they come in for a building
Setback?
permit,
The setbacks around it, he said that it was issued, never discussed about the setbacks on the lot. So the lot setbacks they will meet the code of the county,
They will be required to meet standard setbacks when they come in for a building permit, and that's the time that that will be determined.
which will be 27 and a half and 15.
Yes,
Is
sir.
that correct?
Yes, sir.
Okay. Mr. Pleat?
Good evening, good afternoon, Mr. Carpenter. I have some questions.
There are extra copies.
I did not write this email. I'm not sure exactly where that quote came from, but that is not the reason. I think he misstated, if that's your question.
Mac and I are
The narrow road was the 14 feet of easement, which is inadequate for fire life safety access. It was already in place. The houses behind it are already there, already built.
my question is,
That is not the reason that I,
you know, when you're there. Page 12 of the presentation of the account is the technical review staff findings of fact. That's your signature on the bottom of that.
that's right.
Because I know you're great experience in that time when you issued this technical review decision, you feel you have determined that this is going to be denied to increase the traffic
The 14-foot width was inadequate, and Sammy's statement at the time was it didn't meet the requirements because of the 150-foot lane.
at that time.
That's true, and then I changed my mind.
All right, Mr. Carpenter, now let's take 14, please. Page 14 is a letter of email from Mr. Lambert to Mr. Sanchez. Safety Secretary back after our discussion. Requested that you and my question is, do you agree with Mr. EO is required?
That is the position we were taking at that time.
What were you, what was the department basing that decision on?
Fire department.
Was the fire
Because we were going to be increasing the size of the roadway. And then I changed my mind.
on page 15, June 27, 2019, in communication with Mr. Lambert from my office, makes a statement that, hey, apply for have to go to you agree with Mr. Lambert's statement that an option
That was the position we took at the time. The last part of that statement related to the 300-foot range of notice is incorrect. The condition is listed because of a prospective change to the development. You will notice that in the staff finding of facts, the last bullet point before that statement is the proposed lot split fronts on Sea Turtle Drive, which is a private drive with a maximum width of 14 feet with a deeded easement of 20 feet. So that indicates that 20 feet met our requirement. That was the only outstanding condition.
I guess that was page 12.
May 23rd, 2019. Yes, sir.
What was the date of that?
This looks like this is June 17th, 2019.
As of June 17, 2019, this fire marshal Sanchez, what he was concerned about was that
Yes, sir.
now, if there was a deficiency under the planning, the applicant allow,
Yes, sir.
did that happen?
We issued the denial before allowing you to correct the deficiency. And we granted that opportunity. They did correct the deficiency, making the application approvable, or each of the two applications approvable.
Do you have any questions? Or is it, yeah, you good?
Covered everything.
Thank you, Mr. Carpenter.
In summary, my clients have met all the requirements under the planning code. There's been no showing of any specific provision of the planning code for a lot split by the appellant that we have not met. Therefore, the standards under 1.1310, we are entitled to have you affirm the findings of the planning department and deny the appeal. Thank you.
Mr. Pleat,
Speak further, Mr. Chair.
anyone else? Board good? We fix and close public discussion? Motion to close it?
Make a motion to close
Second.
public discussion.
Second.
All in favor, aye?
Aye.
We have an appeal of the planning department's decision. We can uphold the appeal, or we can deny the appeal. We need a motion.
Make a motion to affirm the findings of Walton County Planning and Development Services and deny the appeal.
I'll second.
Discussion? Ms. Waterman, we'll start with you. Mr. Huggins? Bill's always got something to say.
I think it's unfortunate Mr. Pleat's argument neglected to include the email from Sammy Sanchez on June 17th. Because I think that was the turning point in the decision for the planning department to move forward with the lot split process, which was the correct way to proceed under the land development code.
I'm gonna take the opportunity to pick on the planning department. Unfortunately, it's been my experience that they like to look at things the hardball and not allow stuff, and then I think he realized he made a mistake and he backed up. And I think he did what he should have done when he went from a minor development to a lot split. And I just gotta pick on you a little bit, but that's my position, and I think that it, you know, that there's no way we can uphold the appeal. I just think that we have to approve it, what's been submitted.
I don't see where he erred in any way. The original applicants were allowed a lot split. They applied for them. There were conditions put on them, and they corrected them. And it was approved as allowed.
I made the motion.
We have a motion, we have a second, all in favor, aye?
Aye.
Opposed? We denied, the appeal has been denied. Mr. Pleat, you have 30 days after we have the final order to file the appeal in the circuit court. If you file in the circuit court, I hope you will address the issue of allowing Mr. Shipman to speak on behalf so we can get that settled. We appreciate it. Carpenter, I hope you don't mind me picking on you some, but man, loosen up.
That's just fine, Mr. Chairman. We do reserve the right to reconsider the facts
That's
and
right.
make the appropriate decision.
That's right. Oh, I agree. Okey-dokey. We're going to address the minutes. Have a motion to approve the February 28th minutes.
Motion to approve.
Second.
All in favor, aye?
Aye.
Motion to approve the August 22nd minutes.
Motion to approve the August 22nd minutes.
All in favor, aye?
Aye.
Not very often we get compliments. A few months ago, we had, I forget the name of it, everybody. There was a gentleman that was in the audience that spoke on behalf of, I think we ruled against what he spoke in behalf of, but he wrote an email to the planning department. And they forwarded it to me, and I forgot to give it to you in June, but I was, impressed with the fact that we had a compliment, and I appreciate the fact that he recognized the board and the job that we do. So I wanted everyone to be aware of it, and that's what Mr. Carpenter got for us, and we appreciate it.
I made both motions to approve the minutes. Charles McKinley.
I second.
Sure. Everybody else good? Motion to adjourn?
Motion to adjourn.
Second?
Second.
All in favor, aye?
Aye.
Aye.
Very well. Mr. Pleat, we appreciate it. You do good for your client.
See, I think Mac was gonna turn it down because it didn't meet the fire, still didn't meet the
Yeah, but you shouldn't have never